I'm like an addict, do I gotta have it. I ain't even playing, got a really bad habit. If it moves, gotta grab it, fuse like a magnet. Lose, won't have it till I'm doomed in a casket. I ain't playing, got a weird mind. If you work 8 hours, I'ma work 9. If the shit tastes sour, you should taste mine. I'ma stay in power for a long time. Get up, nah, I ain't a quitter. Toss me the ball, I'm a really big hitter. Big picture, I'm a straight killer. Rising the song to the highest bidder. Got juice, got gas, I'ma move fast. New shoes, new tracks, like who's that? I'm new, come back, better than last. Yeah, it's a new me, never gonna look back. Never gonna look back. Cause damn, I was built to last. You move slow and I move fast, and that's facts. Only I can make a change. Slowly take a step today. I will never be the same. Cause that's what it takes.
Yeehaw! What's up, Corax? How you doing tonight? Can you hear me? Corax, are you there, buddy? I was talking to him before we went live, guys. How y'all doing? King Arthur, Finney T, Chris, good evening to you. Corax, check your mic. While we're waiting for him to come back, let's talk about some AMC price action here real quick. Let me bring up a screen. Sounds like he stepped away to pour himself a drink.
Finishing off the last of this old smoky moonshine.
I've got one. Oh, my wife loves that old smoky moonshine. We discovered it on a trip to the Smoky Mountains and brought back a whole case of it on the plane, only to realize they sell it at the damn liquor shop down the street. What a bunch of noobs. But that stuff gives me a headache. I can't drink it.
Yeah,
it does taste good though.
Especially the cream ones that are like Irish cream. I have this banana pudding version that's a really addictive.
Oh yeah. If you ever go tour the Smoky Mountains, go to the places that do the tastings, you'll get fucked up, man. They'll give you like 12 or 15 of those smoky things, and they have maybe a 30-minute presentation which is quite entertaining. The people behind the bar, and I think it's free.
Oh wow.
But they're hoping you're going to buy some, and we did. Anyways, AMC price action today, new, I think 52-week low today, 652. And I have up on the screen, we're going to talk about the lawsuit in just a second, but I know some of y'all are wondering what the heck's going on with the price. So I'm just going to share 30 seconds of thoughts, and then Corax, if you want to share any thoughts you have. I've been telling my Discord folks and anybody that will listen on the lives for the last year that I thought Q4 was going to be weak. And so downward price pressure for theater stocks in Q4 is not surprising to me. Q3 I thought would be weak too, but we had Barbie, which way exceeded my expectations. On top of the relatively weak Q4, if you just go look at domestic box office numbers, there's no argument that it's weak at this point. We still got 6 weeks to go. So I'll remain hopeful, but we're not on a great trajectory for Q4.
Yeah, I tend to agree with you that I'm not too surprised by the current price action. Like, just traditionally speaking, Q3 and Q4 is not great for any theater company.
Right now for AMC, my model's predicting, maybe $100 million loss.
You've been pretty spot on with those. I'm impressed.
Well, we'll see. We got 6 weeks to go. It's way too early for me to say with any certainty how it's going to be. Besides the weak Q4, we have the dilutive effect of that, the sales that they're sharing right now, the shares that they're selling. I might need to pour myself a drink, correct? I can't even talk straight tonight. So that's going to provide some downward pressure because you're diluting the value of existing shareholders. Plus, the AMC's probably selling a little bit every day, maybe generally about 10% of the float is what the company's contributing with selling shares. That's just a rough, back of the envelope type number. I don't know what they're actually selling, but typically that's what they'll do. If there's always a if, right? If it's at a price where they're willing to sell it, because they instruct Citigroup or whoever the resellers are every day how many to sell and at what price. And maybe they don't want to sell below 7. or maybe they do.
I
just don't know.
The way I've seen every time they put a sell offering out, it's usually there's some sort of bullish news like this. They dropped it right after Q3 when it was looking stronger than it would have been, or the price gets above like that $10 mark. That seems to be about the sweet spot where Adam says, open up the vaults. We got more shares for you.
Yeah, well, we'll find out. No one's going to know anything really. We're all just guessing until they say that they're done. They might not be selling anything for all we know. It just could be concerns over Q4. So at any rate, as far as what I'm doing, because I was eyeballing that price drop all day, like many people were saying, should I get back in? And so I'm just looking at the 13 and 48. I'm kind of looking at the chart. Like I don't want to buy. I have no shares right now. I sold on the run up to 1120. So I'm out, but I want to go back in and buy cheap like I did a couple 5, 6, 8 weeks ago whenever I was at 7 to 8. And I'm looking at the chart, and I don't want to jump in till I see a confirmed reversal. So I'm watching the 1348 EMA on the 5-minute and the 1 hour, and it almost crossed at the end of the day today on the 5-minute. You can see that right with that 13 EMA crossing right above, it's almost right above the 48. And there's a lot of different things you can look at. RSI, MACD, never just use 1348 by itself. And when we go look at the 1 hour, same thing. You can see where the 1348 cross happened here. By the way, I don't charge for this information like some channels do. Right where this cross happened, you could see it went into a severe sell-off a couple hours after that. So if you're wondering, does this really work? Actually, it does kind of work. And we'll see when we see the reversal, we'll see it first on the 5-minute, and then you'll see it later on the 1 hour. So I look at both. That's just one thing I'm looking at. The other thing I'd like to hear from AMC before I buy back in is that they're done with the dilution, but I don't know if we'll get that news.
Yeah.
So just be careful, guys. I know there's a lot of people saying buy the dip, blah, 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 but we don't want to ever catch a falling knife. And if you're trying to flip your shares, into a profitable trade in a couple weeks, or if you're just trying to average down, you probably want to do the best for yourself and wait till it's as low as possible with a confirmed trend reversal. I have people in my Discord that think it's going to $5. I don't know. I can't tell you how low it's going to go.
We do not have crystal balls, unfortunately.
Right. None of us have crystal balls. So I did not buy in. I did not buy in today, no matter how tempting it was.
I will say for my part, equities in general, I've been staying away from. If I see something that looks tasty, I'll go after it. But it's hard to be in equities when the government is willing to give you 4 to 5% risk-free.
That's something we've talked about from time to time. Like, why is the stock market doing so bad, over the last couple of years? Because interest rates are high and stocks are risky, especially stocks that are losing money.
Mm-hmm.
All right, let's. So that's all I really want to say about the stock. Just be careful. Just be careful. We want to talk about the lawsuit that Mr. Al and Mr. Affolter have filed. And I'm going to be straight up with you guys. I have not read through this entire thing.
It's 200 pages. I don't blame you.
I've diverted my research time to other tickers because, it's time that we start talking about other stuff besides just AMC. It's going to be in a bit of a lull due to the reverse split and the dilution that the company must do because of the balance sheet and the working capital. Same thing that we talked about for the last year. I know it sucks, absolutely sucks, but the balance sheet is screwed up and they're trying to fix it. So let's talk about the lawsuit, Mr. Corax. Now, he's on his second revision, right? There was originally a filing done how long ago?
Let me pull that up. I should have it here.
And you did a video, and I think you actually gave them some tips, and they amended their complaint
based on it.
So I'm hoping that tonight maybe you can give them some other tips about any weaknesses, because we'd all love to see Citigroup go down, right? If they did something wrong, and
if they did something wrong, then they should be punished, but they have to prove that first.
Right. I don't know if they have, guys. I have not read any of this shit. So I'm just here to facilitate a conversation tonight.
I'm looking on Pacer right now. Their initial complaint was filed October the 6th. And then
can you summarize for the folks that didn't watch your video a couple weeks ago, what tips you gave Jordan and Al back then, after October 6th? What was the material weakness in the original complaint?
That it was sloppy. It looked like they basically took stuff and just threw it against the wall. What happened was, what he had done is Al from Boston had submitted some memorandums to the original Delaware case. And what they had done is they had taken those and then just slapped a complaint onto it without really organizing everything. Their initial complaint was missing a pleading, which is really important for a court, because the court can't do anything for you, even if they think you're right, if they don't know what you want from the court.
So when you file a complaint, you have to close it with a pleading, like we asked the court to do this, right?
Yeah.
And that was missing from the original complaint?
Correct.
Which is kind of like a major oversight.
Yes.
So did they amend that in the second update that they did?
Yes, there is a pleading in the second one. They also filed, they also had a lot of their arguments for some reason were in their exhibits, and they fixed that. That's why the new complaint, the amended one they have, is like 200 pages long, because they took all these arguments that they forgot to take out of the exhibits when they submitted them and put it into the complaint. That was the other big one. And the last big one was just lack of citation. They were just saying things and not putting any citations or footnotes or anything. So the only conclusion you could come from that is, I say these things are happening because I say so. You have to go through and be like, this is the argument I'm making. This is the law attached to it. This is the different facts and things that are attached to that. And that was completely missing from their initial complaint.
Now, in my drive-by social media perusing, I'm already hearing people take these allegations and saying these are facts. Mm-hmm. These are facts. Yeah. And I just want to say, as an independent observer of court, allegations are not facts until they're proven and decided on by a judge or a jury. Am I wrong there?
No.
Would it be premature to make videos saying that we got something factual here and Citigroup's going down?
What we have to also remember is that the deadline for a reply, which may get bumped back because they amended the complaint, but I don't think it's anything too material. So even if they did, they wouldn't have pushed it back too far. But the current deadline we have right now is the 6th of December. For replies. So right now, all we have is the allegations. We haven't heard anything from the defendants yet. So you can't even really form any opinions until you've heard what the other side has to say about it.
Sure. To a reasonable person, that makes sense. Can you give us a rundown on some of these juicy allegations? I'm just trying to catch up my audience and myself, because you've spent a lot of time looking into this. Yeah. I have not.
I want to say before I get into their amended complaint that they did file for injunctive relief, but since they recently filed for a motion for summary judgment, that was another thing that I had brought up, that they had brought up that they wanted injunctive relief, basically like what happened in the Delaware case. The problem is they're asking for recovery of monetary damages. And the first big header thing about injunctive relief is it has to be irreparable harm. And by definition, if it's monetary damages, the harm can be repairable by cutting a check. So
for the non-attorneys or non-legal folks, can you just give a quick breakdown of the definition of injunctive relief?
It's basically you're asking the court to halt the other party from doing something that would not be able to be fixed by the court, or would cause the party and would cause the party's injury. Not an or, it's an and. So you want the court to say, until we have resolved this issue one way or the other, you will stop doing these things.
Now, like, one thing I heard you say in your first video, I think it was your videos, they're asking for all of the bank accounts of all of these entities to be frozen.
Yeah. That was another one. The third and fourth point, there's 4 pillars for injunctive relief. There's is there an injury that could take place if this is not granted? Is it irreparable harm? Will the non-moving party be injured more than the moving party? And does it serve the public interest? And if you're going to go around freezing a bunch of bank accounts in a very large bank that is Citigroup, it's kind of hard to say that that doesn't harm the general public good.
Right.
And that was something that I had brought up.
I see people in the chat asking, is this a class action lawsuit?
No. It is not a class action lawsuit because they are filing pro se, and by law, you cannot file a class action lawsuit pro se. It's the reason why in the Delaware case, they had been rejected as far as their intervention into the Delaware case. They were pro se litigants. They couldn't take over the case even if they wanted to because they were pro se.
So right now, if they were victorious and there was an award, it would just go to Jordan and Al.
Yeah,
right?
For the amount that they're claiming of $700,000.
Now, can they convert the lawsuit at some point to a class action?
If they get a lawyer.
If they get a lawyer. Okay.
But that's a big if, because a lot of these accusations are kind of weak. And so when you have your reputation being staked on a case, and very well, if it's particularly frivolous, your license being pulled, cases like this that start out pro se, it's really hard for a lawyer to be like, yeah, I want a piece of that action. You would ask for some severe revisions probably to make it something that would be palpable.
In my experience, if a lawyer sees a juicy payout, they're gonna, it would be easy to get a lawyer if your allegations have, a good chance of being proven or a good chance of getting a settlement.
Correct. Because even if you don't get your fees up front, you can always do like what happened in the Delaware case, where you can ask for contingency, where you get paid out from the settlement.
So that struck me. That part struck me as a little odd that they decided to go pro se. Like, did they even attempt to talk to some securities attorneys?
I have not heard one way or the other, to be honest, on that. The only thing that I've had, and that's like hearsay, was that, Bubby had, CSI had said that they plan on doing that at a later date, but why rush that? If you're interested in making this a good swing, I would think that's something you'd take your time on.
You'd want to get all your I's dotted and your T's crossed with a good securities attorney before you file the initial complaint, just to not get it tossed out.
Yeah,
I would think. So yeah, I don't know. I mean, I'm not judging, but
yeah,
I would have. If I thought I had something really biting, I would have gone and found an attorney willing to take the case.
Yeah.
So give us the rundown on the general complaints.
The general, that's really, it's a bit hard to do. Like there's some of them that I've addressed and I've talked over, but it's a 213-page complaint. I've gone over some of the more.
Who are they suing, for anybody who hasn't seen it?
They are suing Citigroup, Citidel Securities, FTX, Alameda Capital, and Alameda Research are the same thing. Antara Capital, the New York Stock Exchange, which is an SRO. We'll get to that after.
Self-regulatory organization.
Which makes it a little bit more challenging. Susquehanna, Mudrick Capital, Virtu Financial, Fox Business, NASDAQ, another SRO, Goldman Sachs, and they have 1 through 20 John Doe defendants.
No FINRA in there?
No. FINRA and the DTC are what's called nominal defendants, along with AMC and Highcroft.
Okay.
A nominal defendant is you are not the subject of, you're not a defendant as in they're making allegations against you, but because you're the you're kind of an interested party. You're the subject. Like they're suggesting that all these defendants did stuff that harmed AMC and Highcroft. And I assume they want to serve the DTC and FINRA. They're not necessarily parties to the action, but in order for the court to be able to have, power over them, you need to include them in your lawsuit. So they're considered what's called nominal defendants. They're not liable if a verdict came down, but it's important that they're included in the lawsuit.
Okay. All right. Sorry, I interrupted you on the rundown of the allegations.
No problem. Just one thing before I cover that. The NASDAQ and the New York Stock Exchange are SROs. Those are way more difficult to go after because it is established federal law precedent that if you're an SRO, they are immune from civil suit. The only people that can sue them is the SEC or a federal agency, so long as they're doing things within their regulatory sphere of influence, us normies don't get to touch them. Yeah, I know that sounds kind of
the deck is always stacked against us, isn't it?
Yeah, but since they're kind of like a quasi-government organization is the best way to describe how law treats them. They're regulated by the SEC, but they're independent, and they're not a government agency, but they get government-like powers.
Hang on. Bender Harris says, Tony, it is hard to address your AMC opinions when the community has been doubting your integrity.
I'll let you handle that one.
If you doubt my integrity, then you haven't been paying attention, and don't watch this video. Then the people that actually want real information are here, and that's who I'm here for. Not here for conspiracy theorists and people that doubt my integrity. All right, carry on, Corax.
Yes. Now, the first one that I kind of brushed over in my video that's here on page 38 of docket number 20, which is their amended complaint. You said in our previous chats that you had a lot more into the history of this because I had only heard about it till like this summer, and that's the whole Brazilian depository receipts thing.
Yeah, I dug deep into that 2 years ago to debunk that whole thing because it was going around like a wildfire 2 years ago. So I can talk to that, but I also have 3 videos on it, the last of which is the most relevant. The first 2 were kind of like investigatory process, and the third one, after a month of looking into it, was kind of like my wrap-up summary.
Yeah, to my understanding of it, like it's not any different than the American depository receipts. A bank buys securities on a foreign exchange, they hold them, and then they issue securities in another foreign exchange that has value based on their holdings of another security on the foreign exchange, so that people can trade on a securities exchange much more easily that they wouldn't normally be able to. And there's nothing inherently wrong about that. The allegation that they made that it requires approval of AMC or the shareholders is just factually inaccurate. You can, Citigroup, how they did it is what's called an unsponsored depository receipt, where they do exactly what I described. They buy them off the open market and then securitize them. And these are like pieces of property. If I buy like a chair from Walmart can't dictate to me what I do with that chair, so long as I've paid for it and it's sitting in my house.
Where people got really confused with Brazil is they were showing the market cap and the number of shares equal to the NYSE, which you kind of got to do to keep the numbers making sense, right? But I urge you guys, and maybe I'll put a link in the video description when we're done, to the Brazilian market to go look at the volume trading. It is, last time I looked, it was like a couple thousand ADRs a day. The amount of volume trading over there, guys, it's ridiculously small. It's an afterthought of an afterthought because the Brazilian market's tiny. But they're trying to make it easier for Brazilian traders, and you got to be they have levels of traders over there. Like your common guy can't even trade these. It's for the more, what's the word? I want to say experience, but that's not the right word.
Professional.
Not professional, but we'll go with experienced or professional for the moment till the word comes to me. Only a portion of the market can even trade it. But the thing is, to add a little bit of granularity to what you said, I never did figure out which bank created the Brazilian depository receipts. Maybe it is Citigroup. Let's just say it is. Yeah. Let's just say it is. Anybody can go down there on their own and create depository receipts. They did not need and did not have AMC's approval. Mm-hmm. What they have to do is go to a Brazilian bank and basically put, let's say, 5 million shares on deposit, saying this is our collateral. And then they divided them. I think at the time, if I recall, it's been 2 years since I looked into this, they divided them by 8, whatever number they had. And so each BDR was worth 1/8 of a share. Yeah. Kind of like when, they took the preferred shares of AMC and created a 1-for-100 ape. When you create a depository receipt, you get to decide how much you're going to divide it by.
Yeah. And accredited, was that the word we were looking for?
Accredited. Yes, that is the word.
I saw that in the chat. See, chat's always helpful.
Yes. Thank you, Feed Jake. I'm pretty sure I covered all this in my video 2 years ago, but I so thoroughly debunked the Brazilian depository receipt stuff in 2021. I haven't even really looked at it since then. I'm just shocked that it's even coming up again now. But yes, the bank or the institution that created the BDRs has to have legit shares as collateral. But those shares are not trading, guys. Those shares are not trading. They're collateral. And they create these receipts for the shares. So I know people are saying they took unregistered shares and they pumped them into. No, that's a complete misunderstanding. You take registered shares, you put them on deposit in a bank, in an institution down in Brazil that the government approves of as collateral, and then you get approval to create receipts for those shares, which can then trade in the Brazilian market, just like NEO trades in the NYSE. You're trading depository receipts of the NEO shares that are over in China.
Yeah, because in China,
they have to be backed by real shares. But same thing with Germany. The AMC has shares trading in Germany on depository receipts. No one ever questions that, which I find humorous. They focus on Brazil for some reason.
I don't know why either. And I also would note that I don't think it was brought up in the allegation, but I've heard some floating in the wind stuff about, well, then these could be used to be a locate for shorts. No, they are on the Brazilian exchange, number one. And number two, any sort of derivative, the SEC bylaw does not allow to be a locate. You have to have actual shares as a locate.
Yeah. So if you want to get educated on it, I don't think we need to waste this whole live stream. Go watch my last video 2 years ago on Brazilian depository receipts. And hopefully that'll add some clarity. And maybe Al and Jordan can find some useful tidbits in there too. But I think that I'd be shocked if you could prove any illegality going on with BDRs.
The next thing they bring up, we'll just skip over because I think that one will be thrown out pretty quickly. And it was dealing with the whole Project Popcorn stuff that was dealt with in the Delaware litigation. And this part of the settlement is that they are completely, that whole matter's been resolved.
Well, it's been resolved with Allegheny and AMC, but what about Citigroup, FTX, everybody else? I mean,
that's a good
could they
question.
be roped in
for their participation in it? That's an interesting question or angle of that I hadn't thought about. Well, I mean, you'd have to determine if that was illegal. I think we both said that that's kind of morally questionable, but as far as illegal, as far as federal securities law, I don't think it is. Because, we both discussed this was something that they kind of had to do. Was it a dirty kind of punching shareholders in the gut? Yeah. But it was that or bankruptcy. Which would you like?
Yeah, we don't need to rehash that.
Yeah.
I think my audience gets that.
The next one that they have was the ones that we recently got hot takes over, and you've also done a video on, and that's the air quotes alleged sale of unregistered securities by AMC and Citigroup, where that they were apparently they were selling APE before APE existed.
So if you've read through the complaint, what is the basis of the allegation for that?
The basis for the allegation of that, I would love to be able to tell you, because the links that they give in the footnote citations are broken.
Wow.
I tried. Well, here's part of the problem with it. Since they clearly sent in a paper copy to the court, like hand delivered, all they did was photocopy it and throw it up on Pacer. So I can't click on these links. I can't even copy and paste them. I have to hand type them in because it's just a photocopy. It isn't like with some of these Delaware filings where they were digitally filed. And so I can go in and copy and paste them out. I had to hand type in the URL, and the SEC website came back. Yeah, that doesn't exist.
I hope the basis of the complaint is not the stuff that we already debunked, where they footnoted in the 10Qs why they were retroactively showing the tables,
yeah,
on a date before APE was created to make accounting sense to the, to the reader of the 10Q. I hope for their sake that is not the allegation, because that's gonna fall apart real quick.
Yeah. History is, I'm having to like cursory go over some of these because I know the ones that I've hit before, but like I said, it's like 200 pages of like they took a shotgun and just fired and are hoping some of this sticks. Oh, here's the reason why that they're going after Citidel and some of these media groups. Like,
yeah, tell us why they're going after Citidel and FTX, if you can remember from your reading.
On page 91, section H, they go over how Citidel was taunting investors and that they had some of these media outlets had been posting articles on AMC, and they think that they were defamatory and that they injured investors' investments in AMC by pushing down the price. Basically, their whole argument is short and distort.
Okay.
And that's kind of the long and the short of it. They have some citations that go back to their exhibits of, like news articles, but you kind of have to go more than that when it comes to defamation. Defamation, you have to show like when you have like a public entity, like say Citidel or Fox News or Fox Business, they're considered what's called public figures. And when you have a standing as an established public figure, in order to sue them for like a defamation or like a short and distort, which is basically more or less you're accusing them of defamation that caused you an injury, since they are a public figure, they get a step higher tier. It's kind of like a First Amendment sort of protection, where you have to prove like there was a willful intent of malice or reckless disregard for the truth.
Well, I think the defense from Citidel or Fox would be, we looked at the financial statements and the balance sheet is fucked up and the working capital is negative $2 billion, Your Honor. And that is our basis for saying this stock is likely to go down.
Yeah. And that's always a great defense when it comes to defamation, whether you like what they're printing or not. If it's a factual statement, that's the ultimate defense to any sort of defamation.
Was there anything that was just like blatantly antagonizing and not rooted in some fact? Did you read through the exhibits?
I haven't gotten to go through the exhibits because there's 36 of them.
I know Charles Gasparino is irritating as fuck. Right.
But that's kind of what he's hired to be.
With his taunting and all that. He makes me sick to my stomach. But if he's looking at the financial statements, I don't argue with him because he's not wrong on that basis. He's just childish the way that he goes about it. And it's really in poor taste from someone of his position.
Yeah.
The way that he acts.
And that's totally a fair assessment, but it's also not defamation. We still have the First Amendment here in America, and he can say whatever he wants to so long as he doesn't stray into unfactual statements.
Okay. How about FTX?
FTX, that one was another one that I'm not particularly impressed with. It's the whole tokenized securities thing. basically that FTX had these tokenized securities, and someone had made an offhanded comment to SBF during one of the many interviews that he did before the federal government came and whisked him away to federal prison. That he had said that those were 100% one-to-one backed. I doubt the credibility of a guy who's going to prison for 7 counts of securities fraud. But the fact remains that if you look at the SABI case, the SEC versus SABI, the SEC, again, as I said previously, no derivative is allowed as a locate. What happened in the SABI case was the SEC charged SABI because they had these preferred convertible securities. And they were trying to say, because we could convert these, they were trying to tell to their broker, and their broker was like, no. But they were basically saying, we can convert these and then we would have shares, and that is our locate. And the broker was like, no, and then ratted on them to the SEC. So I think that's a good thing. In most of these cases that I've seen where the SEC has gotten involved with these sort of like naked shorting cases, it's been the brokers that have ratted out their customers to the SEC because they don't want to be in the hot seat.
I've just in passing looked into the whole tokenized security thing. It's certainly not my area of expertise, but I just kind of, standing at arm's length, knowing that FTX was full of a bunch of fraudsters and the chief is going to jail, that even if they said they were backed by shares, I have my doubts.
Yeah, I strongly doubt that SBF said anything truthful about them being one-to-one backed. It would just be yet another fraud in the crypto
we
market.
know that they said that they were backed,
yeah,
right? But
yeah.
I have my doubts.
This one, I haven't gotten the chance to thoroughly read it, but I think it's an interesting one because it might be a particularly strong one. They're accusing Citidel, Virtus, Susquehanna, and Citigroup of being in a market manipulation scheme by basically involving omissions, misrepresentatives, and fraudulent transactions, which the way that it sounds that I'm looking at it here at quick glance is that on the fraudulent transactions, it sounds a lot like they're accusing them of spoofing.
Which they very well could be.
Which is it's a hard claim to make because, and this kind of goes for the whole complaint as a whole, that fraud claims, and I can't remember the exact standards off the top of my head, but they have to be specific. Like you have to name not specific dates and everything, but you have to be specific in claims as to who's doing it, how they did it, where they did, stuff like that. So there's a higher standard, a higher bar as far as proving those things. I can't assess right now if they've reached that standard, but I'd say if they're accusing them of spoofing, that's probably the strongest claim they got. And I would personally, if I was the lawyer looking at this and having listened to other lawyers on YouTube, you want to focus on your strongest stuff. And in fact, you should excise from your complaint things that are kind of weak and just focus on this, on the strong stuff. Because the judge is going to get lost. The jury is going to get lost when you go into all these different complicated things. So you should limit narrowly to your strongest arguments as opposed to just shotgunning.
So people like Wes Christian and Share Intel, they do a lot of research to bring a case and get evidence, as I understand it, right, where they can make a spoofing claim, or do they throw it up against the wall and then go try and get the evidence? What's been your that case that you're following right now? What was the order of events that they did on that one, trying to prove spoofing?
Oh, on the Sorrento Therapeutics.
The Sorrento case, yeah.
Yeah, so that one's a bit complicated and a bit different.
A case, guys, which has been going on 19 years.
Yeah, I saw that post that you made on my comments section. I was so surprised by that one. I didn't realize it had been going on that long. But what I do know, and I have the hearing, the audio transcript on my YouTube channel, The lawyers did a good job of summarizing what had happened so far, at least in the context of the bankruptcy, which is that Sorrento had done 2004 discovery requested on some of these brokers because they're going to bring lawsuits against them inside the bankruptcy court. The brokers provided a certain level of discovery and Sorrento wasn't exactly satisfied with all of that. There was some legal haggling that went back and forth. The brokers brought in, I guess, an expert who said that they couldn't find any proof in the data that was available that the brokers provided and that was provided by Sorrento that showed proof of any sort of spoofing or anything. And at the end of it, they decided to settle, where they would make the Sorrento, the spinoff holding company, available to be purchased by short sellers to close their position, which to my understanding, many of the short sellers did. It wasn't a confirmation that there was any naked shorting, just probably some people had some profits and they wanted to get out of Dodge while they still could, because, even while it's in bankruptcy, I mean, we've seen Bed Bath & Beyond, the crazy fluctuations that had. So better to close the position, not have to deal with it.
Yep.
It was re-brought up again when they brought in Wes Christian. Wes asked for discovery again against the brokers and then against FINRA and the DTCC on basically the same sort of allegations and some of the spoofing stuff. The court, which now has a new judge because the old judge who was in the case was removed because he's actually no longer part of the Texas federal bankruptcy court, because he had some improprieties that were non-court related, but are considered what we call, there's a word I'm looking for, ethics problems. And so he was removed and a new judge was appointed to the case. He said, since the broker stuff has already been dealt with, unless new information comes from the DTC and FINRA stuff, they're not going to, grant the discovery as far as the brokers, because, we already did this song and dance. We're a week away from finalizing the bankruptcy plan. Why are we doing this song and dance again?
Gotcha. Okay.
They also said that they were going to, as far as the DTCC and FINRA, because they had not been properly served yet, they're going to have a continuance till they can actually appear in court and say, hey, here's the story, as far as that discovery. So it's a bit complicated, but generally when Wes goes after something, it's spoofing, because that's the one that's most credible. Everything else is just really hard to prove when you're an outsider looking in and not the SEC, who has access to everything.
Someone is asking about the debt. I just want to touch on that real quick. So on the latest 10Q, AMC has total debt from an accounting perspective is $9.4 billion. However, I break it down because the leases, they sign these long-term leases on the theaters because they're renting most of the facilities. Anything that's beyond 12 months of payments goes on to a long-term liability. So if you have a 10-year lease, 1 year of that will be on your current liabilities and 9 years will be on long-term liabilities. And I'm looking up here at the balance sheet. That gets counted by some people when they're doing drive-by comments as debt, because it is in the liability category. But I differentiate debt, but I differentiate it between long-term debt and long-term capital lease obligations. So if we're just looking at debt, money they borrowed, bonds that they sold, they've been paying it down. A year ago, it was $5.2 billion. Currently, it's $4.75 billion. So that is what I would call debt. And they have been paying it off slowly as they get cash available, but we still have a substantial amount, $4.75 billion. The long-term capital lease obligations, that is never going to go away. I don't consider that debt. That's just me. I mean, an accountant.
Yeah, I'd say that's fair, especially since looking at it, not just from an accounting, but from a business side, if you were to own those buildings outright, what would be your capital expenditures every
Right.
month on that. It'd be crazy.
Plus the amount of money you'd need to buy them to begin with. So anyways, hopefully that answered the question. 4.75 billion.
So the next one I found here that I also brought up in my video was page 118, and that was on the failure to delivers.
Okay. What do we got there?
Basically, the same argument that has always been with the failure to delivers. They've been on the threshold list for X number of days, and that clearly shows that there was market manipulation. They're failing to deliver shares. But from my understanding of how failure to delivers are calculated for the threshold list versus what the SEC looks at is two different things. So the threshold list is just an aggregate. If there's even one failure to deliver, in a given period, it'll remain on the thresh list until the system clears out.
Let me rephrase that.
Yeah, it's probably a bad explanation there. But.
You have to have a certain number of fails to reach the threshold, and then you go on the list. So let's say institution A breaches the threshold and it goes on the FTD list, then you're automatically going to be on there for 5 days. Even if they cleared the fail the second day, it'd still be there. You'd still see the list, the ticker on the list for 5 days.
And if they clear that on, like you said, day 2, but they have a new failure to deliver that comes up.
I was going to say, if institution B fails on day 2, now you just added 5 more days. And if institution C fails on day 5, you added 5 more days. So you could be on a threshold list for 6 months and there could be no impropriety going on. It's just this chain of institutions failing, passing the hot potato around, so to speak.
Yeah, and the SEC looks at individual actors and they punish based on if a particular transaction goes over a certain day amount.
And unfortunately, we don't have that granularity. That, for me, with the FTDs, is the most irritating thing. If I could fix 1 or 2 things, that would be at the top of my list. Show us who's failing, show us the quantity, and show us the time to resolution for each entity. Don't just give us a number of fails.
I understand to a certain extent that you don't want to give out account information. That stuff can be excised, but I think that's a lot of problems that investors like you and me, Tony, everyone else, is that just a hint more transparency would be nice.
It creates this illusion, which might be true, of market impropriety. Like it seems like it should be relatively easy to fix, but they won't even address it. They won't address it.
And unless you push them to address it, they won't. You have to remember that the SEC is kind of insulated because all the directors are appointed by the president and confirmed by Congress. So there's a certain amount of insulation, but not just that, like it could still be changed. You could have laws passed, but that goes back to, talking to your congressman, getting a group together and doing that. I'm all for more transparency in markets, but this ain't the way to do it.
Well, maybe they'll uncover something, Corax. Maybe they will.
Maybe possibly. I think that one's one of their weaker arguments. I still, looking back at it, think that the spoofing is probably the strongest argument. Let me see if there's anything else here that I'm missing. They bring up Reg Show, but it doesn't look like it's tied to any specific, like we have evidence here that this was a violation of Reg Show. They're just tying that the accusations that they've made above is a violation of Reg Show. So it's standing on a stool with one leg, basically, and reaching for the light bulb. They talk about, here's why they are suing Citidel, Virtu, and the New York Stock Exchange and all of that. And that they're accusing abuse of the limit up, limit down system, which I think is like pretty spurious, at least.
What way are market makers abusing it? Because those are exchange programmed in. LULD is programmed in at the exchange level.
If I want, like like I said, with a lot of these, I'm having to glance at them because it's a 200-page document. I haven't had a full time to sit down and read a lot of these. But if I had to give the most generous argument to them, steelman their position, that it ties in with their spoofing, where they're spoofing a bunch of claims, which forces the main institution, the New York Stock Exchange, to throw up a limit down or a limit up on that. In the spoofing, with knowing that the limit down, limit up system, breaker system exists in order to manipulate the price of AMC.
Yeah.
So
if they could. Spoofing is where you create a bunch of orders to give the impression that something is going to move a certain direction, but then you cancel milliseconds later a bunch of those orders, so you don't get on the hook, but you've already set the direction in motion, right?
Yeah.
What is there a terminology? I can't think of it off the top of my head. Where what is it when they're trading back and forth with each other to create a price direction movement up or down?
Is that like the whole like ladder attack kind of thing? I don't know.
That might be ladder attacks. For some reason, I can't think of it.
I can't think of it either.
It's late at night, and I haven't been sleeping a lot.
But it's like that sort of spoofing where basically sort of like what happens in crypto a lot, like a sort of wash trading thing where you trade with yourself to push up the price.
Could be wash sale, Candace. That might be what I'm thinking of. Those type of manipulation tactics, spoofing, wash sales, ladder attacks. It would not surprise me if any of those are being employed legally, to the grayest extent of the law, or illegally.
The guy that got arrested in the UK, who, what was it, the flash crash back in like 2012 or whatever, was charged with spoofing, where he was basically doing a bunch of, like you said, spoofing orders, throwing up transactions and then pulling them seconds later to get in the money on his puts and stuff like that.
Yeah, I kind of, based on what you've told me, and thank you for going through all this, based on what you've told me about their allegations, that sounds like the juiciest one that maybe they could uncover something on.
It's the juiciest, but it's also the hardest to prove because of the standard of proof required in a federal court. But like you said, so far, it's the only one that, in my mind, looking over these accusations, that they have a chance with. And if it was me, I'd trim all the rest of this stuff and just focus on the spoofing. But they also bring up dark pools. I covered that a little bit in my video, where, I can understand why people don't like the concept of dark pools, especially when they're named dark
especially
pools.
Since retail is having all their orders routed to the dark pool, and that was not the original intent.
Yeah, dark pools are generally for anonymous trading. If you don't want your trades to have your name attached to them, so you could route them through a dark pool and then they end up on a lit exchange anonymously, or you have these big orders. So a lot of your your hedge funds or your retirement funds and ETFs do through dark pools because they want to keep their price action anonymous. And also they have these large bundled purchases, like when VU goes out, Vanguard S&P 500 ETF goes out and buys more stuff, they're probably buying off the dark pool so it doesn't warp price discovery in the market when they go in and buy thousands of shares all at once.
Right.
And it leads to better price discovery for the fund, because they can get it at a cheaper price as opposed to having to buy it in blocks on the lit exchange.
Now, I'm just going to go out on a limb with a crazy question here. Did they ask for all dark pool trading to be stopped?
Yes.
Why does that not surprise me?
Yes, they did. That was in their one of their things they asked for in their injunctive relief. There was a lot of things they asked for in their injunctive relief that just will not happen. And
yeah, I get the reason for wanting that. Like, what if? What could it hurt? But the reality is, the market impact of something like that is probably too broad,
right,
for their little case to.
And that's the problem, I think, between a pro se litigant and a lawyer. Like, I understand a pro se litigant or someone like me and you going, yeah, what if? Let's see if we can get that. Whereas a lawyer is much more strategic and circumspect, where they're like, yeah, but if we do too many of these what ifs, we're going to piss off the judge.
Would a Massachusetts judge even have jurisdiction to shut down a dark pool?
That's a great question. I mean, they're a federal court, but that's the problem with these circuit courts, these like state circuit courts, is they only have jurisdiction technically over their little area. So, you know, Massachusetts technically only has jurisdiction over Massachusetts. There's some certain situations where you can have cross claims. Like there was a lawsuit that I can't think of over the top of my head. Yes, the GME lawsuit that I did in my second litigation primetime video, where they're suing in, I want to say Ohio, but I'm probably wrong. But in the filing, it says, and for all of the people that are, you know, have used the GameStop marketplace that don't live in Ohio, here are the applicable laws, because a federal court can do that because it's a federal court. Even though it's based in Ohio or wherever it's based in, they can be like, because we're a federal court and can survey the broad swath of all state laws, we can apply them here for certain people who do not reside in this state. So long as you reside in that other state and that law would be applicable to you.
Are there any other high-level accusations that folks should be aware of, just if they're curious about this lawsuit?
Like most of them are like, they're all kind of high-level stuff, but they're not really grounded in a whole lot. Like they're accusing Citidel of canceling retail orders. I'd be interested to see what proof they have for that they just on a whim were like, yeah, retail doesn't get to, you know, buy securities through us when it's these meme stocks. Cause I mean, that sounds like something that the SEC would be able to notice really quickly, or even one of these exchanges would be able to notice really quickly, and they would get slapped pretty hard for doing. Let me see if there's anything else. They've got some more stuff against Fox Business. They bring up Ken Griffin and Gasparino. Basically the same sort of stuff that we already mentioned, where it's like, you know what, you may not like what he says, but he has a right to say it so long as he doesn't actively lie. And that
no one likes what I say either, because I talk about the balance sheet.
Yeah.
So,
and then they kind of summarize stuff. And so here are their charges. 1 count, antitrust and conspiracy, violation of the Sherman Antitrust Act. Count 2, they are bringing civil RICO charges, racketeering, influenced, and corrupt organizations act charges, and the Clinton Antitrust Act. Count 3, breach of fiduciary duty.
I wonder what evidence they have of some sort of institutional collaboration to prove a RICO
for that
case.
RICO charge.
I mean, the hurdles are high to prove a RICO case.
Count 4, insider trading. I'm confused now, because if they're accusing insider trading, then AMC would be a nominal defendant in insider trading. Then why isn't Adam Aaron or any of these? Oh, okay, I get what they're doing. They're saying that Citigroup is insider trading based on their relationship with AMC. Okay.
Yeah, there's supposed to be damn it, I can't remember the word, but there's supposed to be a wall between the banking relationship the investment banking relationship that Citigroup has with AMC versus the trading side, right? That's
Correct.
a SEC legal requirement. They are not to interact. However, we know that people being people, sometimes information filters through WhatsApp or at the coffee shop. Who knows?
On the much lower side, I'm not going to, consider myself immune to this. I have participated in LARPs where we have what's called metagaming, where you use outside information, either intentionally or accidentally, that you wouldn't
Chinese wall.
know
Thank you.
in game.
Yes.
Yeah. Count 5 is spoofing. Count 6 is violations of Reg Show. Count 7 is fraud, anti-fraud provisions, 15 USC 781A2. Count 8 for market manipulation, violation of Section 9A2 and the Securities Exchange Act of 1934. That's basically all the SEC.
Yeah, they just checked all the boxes right there.
Mm-hmm. Count 9, market manipulation. Count 10, FINRA violations, violation of FINRA rules 5270, 5210, 5310, which is meaningless because FINRA is an SRO. It'd be FINRA's job to enforce those, not a federal court. You'd have to ask FINRA to enforce those because those are rules from a private SRO that's not subject to enforcement from any government. That's kind of how the SRO system works. I really feel like I should do a video about that at some point in time because I've had the same discussion on the MMTLP stuff where I don't think people understand the regulatory framework, as it were, that regulates security markets. And I don't blame them. This is not me trying to say, waggle my finger and say, oh, you should know this stuff, but it's really complex. And I think that's been the downfall of a lot of people when they discuss these subjects.
We got a question on the screen for you.
Mm-hmm. Discovery
more of a statement.
Defense might be interesting if they get requests correct and hone in properly on the right data needed from the entities. Yes and no, because discovery is very expansive in what you can get discovery from, and judges tend to be pretty lenient on discovery. But there's also rules against what's considered overly burdensome discovery. Like, you can request from brokers to give you certain information, but unless you have a really good reason and really good evidence for it, a judge is going to be very, shall we say sus about extending discovery to, every person in the offices at Citidel Group to find the one guy who might possibly have breached that Chinese wall, like you said, Tony, because all of those individual employees have a right to privacy. And there's a certain amount of what sort of burdens are you placing upon the defense to go find that one guy that fucked up? I understand that sounds like, that sounds unfair, but you kind of have to look at it from a mechanism from all the parties involved in this case.
I think the frustration from everybody, and I totally get it, is that there is seemingly nobody on AMC's side that is going after all of these allegations, right? Of the last 3 years of improprieties. But there are 30 other companies that I'm tracking that Wes Christian is involved with, that people are working on this. And if something is found, it will waterfall over. But so far, all those stocks have been wrung down to below $1.
Yeah.
And, nothing has come from Wes. So I don't know if people have the right timeline in mind of how long this stuff takes, if it even provides some meaningful evidence.
A lot of people, I think, miss is that justice moves really slow. Just like what happened with the AMC case is just a feat of the Delaware law that was handled as quick as it is. A lot of these cases you see drag on for years before they find a resolution. And even with the Savvy case, they were investigating the SEC was investigating Savvy for about 3 to 4 years before they even filed charges. So if there is some sort of impropriety, we might not see it for another 3 years, because that's how long it takes the SEC. Because I don't get me wrong, I criticize the SEC a lot. I think there's a lot more that it could be doing, but you also have to realize that they're regulating the entire U.S. securities market, and they're horribly understaffed for that task.
Yeah, I mean, we see that when they announce prosecutions or penalties, September 30th, 2023, we'd like to announce that we finalized the investigation from 2011 through 2014, and we've assessed a $2 million penalty. I'm like, motherfuckers.
Well, that's the other thing.
Shit was like 10 years ago.
And that's the other thing. They'll take settlements a lot of the time because they've got to get on to the next case. So if they're willing to, cut a check, sure, so we can move on to the next thing. It's one of the weaknesses of the system, unfortunately. And like, just as an example, the MMTLP situation that happened over a year ago. The SEC didn't file its Wells notice against George Palikaris and not McCabe, Berta until what was it, August of this year?
And it'll probably be years before we hear anything from the SEC.
The deadline I heard was end of this year, but like you said, yeah, we may not hear again from that till next year. So that's unfortunately how the system works.
Mr. Rookie's spamming the chat. I think you're in the wrong chat, my friend. Everybody on my channel is well aware of the financial distress that AMC's in. So thank you for trying, but we've been telling them that the stock was likely to go down.
About that for the whole year.
Yeah, all of 2023 at a minimum, since APE was introduced and we knew that they were going to dilute and convert. Mm-hmm. I mean, the game changed in November 2021, first of all, and then it really changed when APE came out. And at that point, you had to decide, what you were going to believe was going to happen and set up your trading plan according to that. And I did exactly according to the due diligence I provided on here, which was at the point that it made sense, converted my AMC to APE, and then sold it after the settlement was approved because it ran up, and that mitigated a lot of the damage for me. And then I was out of the play for the whole rundown. So we talk about what we think is going to happen. It's always up to the people listening to take that along with what other DD they read on their own or hear out there and make their own choices.
Yeah.
So thanks for trying to save them, but you're on the wrong channel.
Just quickly, the last count was count 11, market manipulation. Basically, they go back over some of them. The only new one that was under this charge was computer fraud and abuse act, which I think they're trying to say electronic wire fraud charges are what they're trying to get there. Their prayer for relief. Plaintiffs request the court grant the following relief. 1, declare that the actions of the defendants violated relevant laws and regulations, included but not limited to federal securities, antitrust, and banking regulations. Award compensatory damages in the amount to be proven at trial, including the loss of investment value and other economic harm suffered by the plaintiffs due to the defendant's unlawful action, in the amount of $765,630 for Matt Al from Boston, and $34,000 in the case of Jordan Affolter, for a grand total of just shy of $800,000. Award market adjusted damages for lost investment performance. That I do not like. You could make up whatever number you want to as to what, because, this is the infinity. Oh God, why did you put that in there? They put the infinity squeeze stuff. Oh my.
What did they ask for in that?
Award market adjusted damages for lost investment performance during the AMC infinity squeeze.
They use the words infinity squeeze?
Yeah, it's also in their complaint. That was not a good decision at all. Award treble damages as provided by applicable statutes for intentional wrongful conduct resulting in financial harm to plaintiffs. This goes back to their antitrust case accusations. In antitrust law, when you have someone who has violated antitrust, the damages are trebled. In other words, they take the damages, the punitive damages that are assessed by the jury, and they 3x them.
Right.
Okay, so they still want their injunction, enjoining defendants from continuing their unlawful practices, order defendants to make full restitution to plaintiffs for economic losses, order defendants to disgorge all profits, benefits, and compensation obtained from their illegal conduct, which I assume they're going to say should go to AMC, award pre-judgment and post-judgment interest on all amounts awarded, award punitive damages, though they don't specify, award fees and costs requiring the defendants to pay the cost of this action. So they want, that is an interesting one. Your pro se litigants, I'd be interesting to see what sort of billable hours they're going to charge for that. And I have several question marks for that one.
Wasn't there also a request for summary judgment?
Yes, they filed along with this motion, a request for summary judgment. Basically, they, in summary, restate their claims and suggest that the court, instead of going to a jury trial, they ask for summary judgment. Now,
for the folks that are listening, can you give them a layman's breakdown of summary judgment request? Summary
judgment request. Basically, it can be asked for by either the plaintiffs or defendants. This is not a one-side thing that can ask for this. In this case, it's the plaintiffs are asking for it. They're saying that the facts of the case are not in controversy. The reason why you'd have a jury is they are there to ascertain the truthiness of the facts. So since the facts aren't in dispute, you judge, just rule on it as a matter of law.
Does the defense get to answer a request for summary judgment and say, yes, yeah, the facts are absolutely in dispute?
Yeah. Well, that's the part of it that I was going to do in a video, but I assume I can just clip the end off of this and call it good. But yeah, no, we haven't had a reply from the defense. So how can we have a request for summary judgment when we haven't even heard from the defense as to the nature of the claims to begin with?
Is that the standard order of way things normally go? You file your complaint, you allow the defendant to respond, you read the response, and then you request summary judgment?
That is correct. What either the defendant or the plaintiff, you would get the response from both, and their lawyers would look over it and they would go, hey, judge, we really don't question any of the facts here. Just rule on it as a matter of law. And then the judge would go through that and he would go, okay, based on these facts and what the law says, this is my opinion on that. And then that would be the end of it.
Okay. So I see they're asking in the comments, they requested a jury trial. Is that correct?
Yes, they originally requested a jury trial. They are now requesting for summary judgment. That's still important because this could still fail. The judge can, the other option is the judge can say, no, the facts are in controversy, which is, I'm assuming, what's going to happen. In fact, when they do reply, I expect it to be a motion for dismissal for failure to state a claim is probably what they're going to go after. So it's still important that they put that they've requested for a jury trial, because if this fails, that's what we would go to if it got past the dismissal phase.
Dom, sorry, hopefully that answers your question that I have up on the screen there.
Yeah. Any other questions? Anyone or you?
What else y'all got for Corax? Again, I'm not following this case. I don't intend to follow it, but Corax, feel free to hit me up if there's some major developments that you want to get out to a wider audience since you're tracking this one.
Yeah, no problem. I don't expect we'll hear anything until the first week of next month, because especially since they filed an amended complaint. So now the lawyers have to go back through and make sure they didn't miss anything, and there may be an extension. It just hasn't been applied for yet. But the way most lawyers do is they take up that full time. If they've been granted to the 6th, you probably won't hear anything till the 4th or the 5th.
So what I heard you say in the last hour, just unsolicited advice, right, would be pare the allegations down to the things that are the most likely to succeed. But I'm sure in their head, they think all of it's going to succeed, right?
Yeah. Unfortunately, but like that's the reason why you hire a lawyer to, people get emotional. I'm not going to say I'm not one of those people. And you need a third party in the room to tell you, maybe these things are not as important as these things, and we should focus on the things that are important. Maybe we can push some of this stuff here, because at the end of the day, it's about getting a case that can win. And say they do get past this, motion to dismiss that is likely coming, and the, motion for summary judgment isn't granted. Imagine you, Tony, being in a courtroom as these guys argue every bit of that 200-page complaint. At what point do you feel you'll nod off and go to sleep?
No comment.
But that's the thing that you have to worry about. And
I mean, the judge is there to pay attention and ask questions, right?
Well, keep things moving at least. I mean, in the case of a jury trial.
But my concern is, and I said this back when they went pro se in the first case in Delaware.
Yeah.
If you want to be taken seriously, these guys, if they show up, the defense, they're going to come with good lawyers,
the best.
I would presume.
Yeah.
And, I would not want to be going pro se.
No.
Against
not at all.
high powered, career investment banking.
Likely people they have on retainer and are the professionals.
So that would be my unsolicited advice. Get a damn attorney.
Yeah. In fact, we do have some of the attorneys that have appeared. You have Joshua Hamilton of Lathan and Watkins LLP, William Weber of Quinn, Emmanuel Urquhart and Sylvan. Yeah, so there's some big names up there, especially Latham and Watkins. So I wouldn't want to be going up against those guys on my own.
Dom is asking if Discovery gets dark pool data. All the dark pool trades, Dom, are eventually reported to the tape.
Mm-hmm.
So all of that is a matter of record. The dark pool is not just like some nebulous where the trades don't get reported. I've done videos where I show you guys where to go. I think it's on FINRA's website where they have the data repository where you can see all the dark pool trades.
And even if they could, it would be heavily redacted because, you've got people's personal information in these trades.
But as far as volume and things like that.
Oh, yeah, that stuff.
But
yeah. Totally.
If he's asking are they spoofing in the dark pool? I don't think dark pools, I don't know that they work that way. It's just a place for a buyer and a seller to come without knowing who the other ones are.
Yep.
They say, I want to sell 1 million shares at 670. And another guy says, I want to buy 1 million at 650. And those orders just sit there in the dark until one of them changes their price. And then it automatically executes. It's an anonymous trading form where you don't know who has how much and at what price until the price meets.
It's like a blind limit order auction.
Now, with the intelligence that all of these high-speed trading firms have, they spend their days trying to create algorithms that sniff out what others are doing in the dark pool. They're all in the dark pool competing with each other, not just with us.
Yeah.
So I don't know how much. I don't know the exact answer to your question, Don, but I'm sure just like on a regular exchange or a regular broker, all of that data is stored somewhere.
Likely with FINRA, I would think, like you said.
And yeah, don't be afraid to ask questions. That is what we're here for. I certainly don't know everything, and I'm sure Corax doesn't either, but
no,
we're just here having a conversation, seeing what questions you have. Sometimes when you ask questions, it spurs us to go dig into stuff. And
yeah, well, like I said, there like the idea that since it's come up so much, some of this stuff with how SROs work, that might be something to make a video or have a discussion on later, because a lot of this stuff is complex, and there's some of this stuff that Tony is given a much better example than I have on the matter on some of these things. So I mean, there's all sorts of stuff to continually learn about with the securities and equities markets that are out there. It's a very complex Gordian knot of transactions.
Ron says, Tony, do you think AMC is going to $4? I don't have a crystal ball, Ron. I was tempted to re-enter my AMC position today, but I'm at this point just looking at the the chart, and I saw no bullish signal today that said buy for me. So I flashed it up at the beginning of this live stream. There was nothing on the chart today that said buy. I'm looking for a trend reversal on the 5-minute and or the hourly. I'm not trying to time the bottom absolutely perfectly, but I don't want to jump in and then 20 minutes later it drops another 50 cents, you know?
Yeah, I know that feeling a whole lot. I've definitely had moments like that.
Could it go to $5 or $4? I mean, sure,
anything's possible.
It could, but I did a lot of work today looking at, going back to 2019, going back to 2020 when we had no income, AMC, and looking at things like the top line revenue, the net income, the cash on the balance sheet, the EBITDA margin, just looking at very top level stuff and trying to say how much can they grind down the market cap of AMC? It's at 1.3 billion. It was around half a billion in 2020 when we had no income at all. So, and we had all the same debt. So I'm just scratching my head, like what is realistic? And like I've said in my Discord many times, if I just give you straight Wall Street financial analysis, I can't tell you a fair value price because the company has no profits and there's no shareholders' equity and the balance sheet's a wreck. So any ratio or formula I would use to create a fair market price is tough to do. Maybe impossible. So the fair value is ultimately when people, the collective market, say it's cheap enough and we believe enough in the future that we're okay buying right here, or we're okay not shorting right here. More importantly, I don't know where that number is at this point. It's way lower than I ever thought it would be. But
to take Jay's question, are FTDs being sent overseas? There's no mechanical way that they could be. The only thing that's regulated that the FTDs are checking is here in American markets. So there's no way to hide them overseas, quote unquote.
But they can place orders overseas. They can trade in other markets if they want.
But that would be an FTD on those exchange, yeah.
Right.
And as far as directly handing, here's the thing about those security sales. They're at the money exchanges. It could be that they're being sold for short covers, but both AMC, the bank, and the short seller are all blind to the trade. They're just closing their position or trading or whatever. Adam Aaron could have, unintentionally sold them to short sellers, but there's no way that I would think that was intentional. He's just selling shares to get in liquidity to the company. He doesn't care who he sells to them. He's just blind to whoever's willing to buy.
I'm gonna hit two of Jay's questions. What about the Brazil shares? Go back and watch the video I did 2 years ago on BDRs. We talked about that at the beginning of this live stream. That was all debunked 2 years ago, Jay.
And we did cover it in this video.
And we covered it again today. As far as competitors are valued way higher and make way less, just as a service to you guys, I did a breakdown of Cinemark, including my dashboard, which looks at things that Wall Street's looking at, including how the balance sheet looks, how working capital looks, debt to equity ratio, earnings momentum, things like that. And I think if you go look at the Cinemark video I did, it's very evident, very clear that the fundamentals of Cinemark are way better than AMC. And they need much less domestic box office to create a profit because they're half the size of AMC. They don't have the burden of 10,000 screens.
That's the big thing.
AMC will be successful if box office can get domestically to 11 or 12 billion. That's when they can start banking profits. But until then, the company is at a disadvantage due to its size. And smaller competitors are more nimble and they have better balance sheets.
That's the trade-off. When the market is good, AMC has all those theaters to capture all that. But when the market's weak, they have so many theaters. It's a burden.
By the market, we mean domestic box office, right?
Yeah.
AMC has the opportunity to crush it if box office gets back up to 2018, 2019 levels. And they've been going up every year. And like I told the guys on my Discord today, the only thing we should be arguing about for the next 18 months, 24 months, and the only thing I'm going to be watching, are we going to get back to $11 billion domestic box office, $12 billion? That's the only thing I care about. If we can't, then AMC is going to have to go in fire sale mode and start cutting costs, because we can't just keep diluting people to infinity. I mean, they could, but I mean, that's a liquidation. It's not going to end well for anybody.
Yeah. Yeah, that's just liquidation by another name. You're not in bankruptcy, but you're basically liquidating like you're in bankruptcy. And that's no good for anybody. So like, I hope the best. I hope the company turns around. You don't want to see people lose jobs or anything like that. So.
And I am tracking on a separate spreadsheet. I don't know if I've shared this anywhere or not, but I'm tracking AMC's number of theaters and number of screens, and they have been actively for years reducing it. So they are actively working to cut those costs. I want you guys to know that. Everybody's, always complains he's not doing anything. They are. They've closed about 10% or more of the screens, and they've replaced them with a handful of new theaters, that handful is outperforming the 1,000 that they got rid of. So they're doing the right things, but when you have long-term leases, you can't just walk away from them. You will get sued for a specific performance, and the landlord will come after you for the entire amount that was due on that lease. So they have to, as a lease ends, is this theater worth keeping or not? If it's not, then walk away.
Yeah. I would, in response to your wife's boyfriend, I'd be very careful about the idea of AMC producing its own production stuff instead of waiting for Hollywood. The reason why they did the Eras Tour thing is the upfront cost to be able to produce that is very low. So the profit they could get from it is much higher. But you look at companies like Netflix, a lot of it is they have outside producers and they just buy the rights to things.
Yeah, I mean, if Taylor Swift or Beyonce or Dane Cook, someone comes up and says, "Hey, we filmed our tour. Would you like to distribute it?" That's a
totally different argument.
That's no risk, right?
Yeah, that's a good idea.
What you were just commenting on is the risk involved with funding a movie.
Yeah.
Right. AMC funding a movie. Sure, we'd all like to see that, but look at how many professional production companies lose money on movies. I'm not huge on that idea, but bring us a movie that you already filmed. Dane Cook, Beyonce. Hang on, my wife just got home.
It's just me spitballing. I'm not sure it'd be a good idea, but like having some sort of like film festival thing where you can just have people bring in already produced movies, and then you're just the distributor for them. That could work out or something like that. But being an actual production company, that's a huge overhead. That'd be too much for a company like AMC.
All right, we'll take one or two more questions. She just got back from a late yoga and grocery shopping, so I'm gonna wrap up. Do you have anything you need to add while we get those one or two more excellent questions, Corax?
No, not really. I mean, that pretty much covers it. I probably will later, once I have a much more time to have an in-depth look at things, have a video on my channel about it, or probably a series of videos, because like I said, it's 200 pages. But I think we pretty well covered, the 40-foot overview. This is what they're doing. This is what they're accusing them of. This is what we think is the best outcome for that situation.
Well, I wish them a lot of luck. Keep us updated, as dates or filings happen that are worth talking about. I'm not going to
eagerly awaiting the 6th
about this lawsuit.
Yeah, no. Well, you won't have to, because it's not moving like a sprint runner like the Delaware case was, where there's literally something going on every day, it seemed like.
Your wife's boyfriend says, what happened with AMC and its own cryptocurrency? Yeah, I don't know. My Popcoin idea. I would have loved to see them do that, but I think in general, as we've seen with GameStop and the crypto market in general, it got a little weak there for a while. So maybe they'll come back to that.
Yeah, and didn't GameStop get rid of their whole GameStop wallet thing because they were the regulatory ambiguity was just kind of not worth it.
Yeah. All right, guys. Thank you very much. I saw a lot of channel members in here. I'll be on the Discord again all day tomorrow. We had a lot of great discussion about AMC and other stocks. I did call out to you guys a ticker on Sunday Night Live, SHOT, which I think ran from it closed on Friday around $3, ran up to over $7 before finishing its nice little run today. So congrats to any of you that made money on that. And I will continue to share those, and shout out to the person who sent me that to take a look at. It's a shot Corax, which allegedly immediately or in short order reduces your blood alcohol content.
Interesting.
And
super sober up drug.
Yeah, they're not a shot. I think it's a drink. And I did reach out to them and ask them to send me some samples so I can try it live on a live stream.
Do something about my hangovers.
Yeah, but they haven't done a double-blind placebo study yet. So I said, be careful. You know, play the momentum on this one. You know, don't be
buy the rumor, sell the news.
Yeah, I knew it was getting promoted. It had run up from 30 cents to $3 before I got eyes on it, but it looked like it still had some legs. And yeah, it had a nice. It doubled in the last 2 days. So, I'll continue to post what I can that I come across and what I'm looking at in the Discord, and the AMC conversation goes on there since we're not really doing it on YouTube. Too many people not wanting to hear real information on YouTube, unfortunately.
Yeah. And if you guys have, I know some of your subs are my subs. If you guys have any like companies that you want me to follow legal stuff on so that you can stay informed on that, because that's part of due diligence too. What's this company doing? What troubles it getting into? You know, I'm pretty open on Twitter or YouTube. If you got an idea, feel free to hit me up.
I put a link to your channel in the video description for folks. What's your Twitter?
It is at Sunny Corax, all one word, SUNNY CORAX.
And I will just warn you guys in advance, Mr. Corax is not generally a fan of meme stocks, right? Is that fair to say? Is it that you're not a fan of people that pump things?
Exactly. Okay. 100%. Me and PP Seeds have a fisticuffs. Okay. Along with the Bed Bath Beyond people. Your guys' stock is dead. Give it up already.
The BBBY?
Yeah.
I heard, unfortunately, that his whole Reddit got shit canned today. I wonder what happened there.
Yeah, I don't know. Oh, well.
Anyways, thank you very much, guys. We love you. We're just trying to provide sensible, non-emotional information here for you. We wish Al and Jordan all the best. And maybe, who knows, maybe they'll find something that benefits everybody.
Yeah, that's the hope.
All right, guys, have a good night. I'm going to run the Corax. If you want to hang out for 1 second, I'm going to run the outro. And if I can find it.
You're about as organized as I am in my
they changed
files.
Up the sidebar of Restream, so I always got to look for it. Okay, here it is. We will see ya mañana. Adios.
Let's go. Yo, I'm like an addict, do I gotta have it. I ain't even playing, got a really bad habit. If it moves, gotta grab it, fuse like a magnet. Lose, won't have it till I'm doomed in a casket. I ain't playing, got a weird mind. If you work 8 hours, I'ma work 9. If the shit tastes sour, you should taste mine. I'ma stay in power for a long time. Get up, nah, I ain't a quitter. Toss me the ball, I'm a really big hitter. Big picture, I'm a straight killer. Rising the song to the highest bidder. Got juice, got gas, I'ma move fast. New shoes, new tracks, like who's that? I'm new, come back, better than last. Yeah, it's a new me, never gonna look back. I'm never gonna look back. Cause damn, I was built to last. You move slow and I move fast, and that's facts. Only I can make a change. Slowly take a step today.